Good evening, everybody. I hope you all are doing well. This is going to be the last live stream of 2024. Next week, obviously, is Christmas. The week after that is New Year's Day. I'm going to be out of town on New Year's Day, so we're going to make the next one the first Wednesday after, I guess, the 8th of January. So this will be the last one for this year, but we'll definitely do it again next year. I've had a great time, and I really appreciate everybody who's tuned in. And we've got some really interesting guests coming up next year. I've got a retired disability judge. I've also got another attorney who does appeals work, federal court and appeals counsel, and she publishes a lot on LinkedIn. And we're going to talk about some of the issues that have been working in terms of getting, my hair's sticking up here, getting unfavorable decisions reversed. So that'll be interesting. And I've got a couple other attorneys who are going to join me. I know Stephanie has come before, and Jeffrey Herman. We've got a couple other people coming on. So it'll be hopefully a good year next year. So I hope this year has been good to you. And again, Social Security is going to be an interesting year. We don't know what's going to happen with the new commissioner. We don't know what's going to happen with Social Security in general. Hopefully, nothing bad, but we're just going to have to see. But we'll be on it. We'll be talking about it. And of course, your questions are always going to be welcome. So let us get to the questions that we've already had come in. A few people have already sent some things in, which I appreciate. And I understand, by the way, when I set this up, what I normally do is I set up to basically say it will be starting at 8:30 p.m. Eastern on Wednesday, but apparently when I did it, somebody emailed me and said it was 10:30 in the morning, so I may have screwed that up. So I apologize for that, but hopefully I know enough people have been here, they know it's 8:30, but for some reason I screwed that up. I apologize. Okay, Ron says, I want to thank you and your assistant for helping me with our reconsideration. Very good. Okay, that's right. We won at recon. That's cool. And this just shows you that you can win cases at reconsideration. We do win cases at initial. We win them at recon. What I try to do is when I do an initial application, if I think it's a grid rule case, if I think it's got a really good functional capacity argument or a listing, I'll mention that in the application or in the reconsideration. So we've definitely had some positive results there. We try to get all the forms in. Just some things we can do. I mean, some of it is, just the luck of the draw of getting a good adjudicator who's willing to work the file. So some of it's just good luck, and some of it is, we're just making their life easier. But Ron, I appreciate your tuning in. Thank you very much. Okay, so less than a year in Texas, I think, and that's pretty unusual because Texas, as I think I've discussed before, Texas and Florida are two of the more difficult states in terms of the amount of time it takes. So getting an early approval in Texas, and I realize that Ron is 100% permanent and total disabled by the VA, so that gets him to the front of the line, which is a good thing, but Texas and Florida are really, really difficult, so I'm really happy to get a Texas case approved early. But thank you, Ron, for tuning in. I really appreciate that. Big one, Mr. Ginsberg. First of all, it's not Mr. Ginsberg. It's Jonathan. I'm not real formal. Anybody who knows me, who've dealt with me, first name basis. We don't go on ceremony here. My earnings statement from SSA says I earned money in the last 4 years that I've been disabled. I've not worked for anyone. Should I worry about this as I'm concerned that if I get a CDR and I've not worked since 2020, don't want to cause a problem? Passive income. Okay, so 2 comments about this would be, one, if your earnings or if your income is passive, meaning that you're getting 1099 from dividends or from rental income, something you weren't doing any work on, Social Security will see that. They may ask you about that, but just like the judge said, if it is done passively, if it's not active earnings for wages, that will not count against you. And passive income in an SSDI case does not count. So you could have an inheritance, you could have dividends, you could have sale of stock, you could have sale of a house, you could have any number of things that are passive that's not earnings, that will not hurt you. But, again, if they do a CDR and they ask about that, you want to make sure you have proof of it. So if you do have evidence, proof that you're getting dividends, let's say, or you've sold a property and somehow you get a 1099, or for whatever reason you get a 1099, you want to make sure you have that available to provide them. But there's really nothing you can do until they ask for it. In fact, I was having this discussion with somebody today, and that is, it's tempting to want to just, assume Social Security is going to want to know about X, Y, and Z, and to send them all this information. That is a mistake in my view. Social Security is a very, it's a very big bureaucracy. It is, a numbers type of thing. Don't give them anything they don't ask for, because it's going to get lost. It's going to cause confusion, and you just don't want to volunteer information in most cases. I just think you wait for them to ask you. The system has got to play out. It's not a particularly good system. It can be very unfair. It could be unfeeling. But I think if you start bombarding them with stuff they don't want, it's going to cause more trouble than it's worth. Just my take on it. So I wouldn't necessarily do anything until they ask you. And another thing he says, if I get a CDR, you may not get a CDR. So, don't assume anything. But if you get a CDR, just be prepared to deal with it as it comes. Okay, Laura Dunnigan. I think Laura was here last week, if I'm not mistaken. Under the grid rules, 55 plus with a college degree, how do I know if real estate agents have transferable skills? Is there a guide for that? Will it matter if I can sit 1 hour or stand 15 minutes? Okay, so first of all, if you look at the grid rules, it talks about high school education or more. So college degree is really not going to make much of a difference. As far as where to look, what you want to go to is occupationalinfo.org. Occupationalinfo.org. That is the DOT, Dictionary of Occupational Titles. In January, the Social Security is going to rely a little bit less on this and really rely more on what vocational experts talk about in terms of their transferable skills. But let's just take a look at real estate agent. In fact, let me share my screen so you can see what I'm doing as I'm doing it here. Share screen, Dictionary of Occupational Titles. Okay, so Laura, just take a look at this. So we've got the Dictionary of Occupational Titles. We're going to talk about real estate agent and sales agent. Let's just call it this, real estate sales agent. All right, so this is considered to be a light job. Light meaning that you'd be standing 6 out of 8 hours in a day, lifting 20 pounds on occasion, 10 pounds frequently. It is also what is called SVP5. That stands for Specific Vocational Preparation. That is going to put it, I believe, at a low-end skilled job. I'm pretty sure that semi-skilled is SVP 3 and 4, maybe 5, but it's either going to be semi-skilled or low-end skilled. And as far as transferable skills, there may be some transferable skills arising from being a real estate agent, understanding, real estate documents, dealing with contracts, interacting with the public. These are all skills that you could take in any kind of sales job. So there may be some transferable skills, but they would have to transfer to sedentary work, and they might. But again, I think what you'll find is that if you have physical limitations that limit you, to the light exertional level, again, not standing more than, if you can stand less than 6 hours in a day, if you can't lift 20 pounds, but then you have non-exertional issues, which would be things like pain, having to use the restroom, being, not being able to keep your balance, fatigue from medication, let's say, things like that are non-exertional, that would interfere with using any transferable skills. So let's say that a real estate agent, I think there would be transferable skills. Let's say that interacting with the public would be a skill, or writing up a sales contract. Well, if you have difficulty with concentration and focus because of medication side effects or depression or pain, then those skills would not readily transfer. There's also the question of whether the skills you've got as a real estate agent would transfer out of the real estate industry. And are there any sedentary jobs in the real estate industry that would allow you to use those skills? I would think that most sales jobs in real estate are going to require you to show property. There may be a few, maybe a small percentage that wouldn't, but I suspect that most of them would require you to be on your feet. So one question I would ask would be, are there any transferable skills outside of this particular industry that you've picked up? Because again, having sales skills in real estate is not the same thing as having sales skills in selling industrial equipment. Let's say, ladders or scaffolds or things like that. Being able to sell real estate is a very different thing. You're dealing with the general public, not in a commercial setting. So I think that, are there skills that transfer out of real estate? Number one. Number two is, are there any skills that transfer to a sedentary type of job? Number three, are the skills eroded by the non-exertional impairments? Again, fatigue, pain, restroom issues, medication side effects, difficulty with, focus and maybe difficulty with balance. I mean, any number of things that could be. So I think that's how I would attack that. But the specific answer would be, you have to really ask a vocational witness, and that may be somebody I can try to get on, because I know a couple of them that would maybe come on and talk to us about these type of questions. But I suspect that there are ways to get around, the transferable skills issue with this, assuming you've got something other than just a physical limitation. Now, again, so I'm clear on this. As of January, Social Security is going to be relying less on the DOT per se. And the reason for that is the DOT was last updated in 1991. Many of the jobs, before that, they recognized that the DOT description of, for example, in a real estate agent situation, there's no discussion of using computers, and of course nowadays, if you're in the real estate business, you're online, you're using cell phones. There's all kind of things you'd have to be doing that are not even considered from a 1991 real estate agent perspective. So because so many jobs are outdated in the DOT, Social Security is now saying to the administration and to judges, we're going to see what the vocational witness says about his or her knowledge about placement, things like that, and other resources that might exist. So the DOT will be a little bit less important. It's still going to be used. My point here is, I don't know exactly how that's going to be played out, because we don't know whether they're going to just fully rely on experience, which is going to make things really kind of crazy, because you won't be able to know. Like now, I look up a past job and I can see it's in the DOT. I can see what the DOT says. If it's all based on what vocational witnesses testify to, I'm not going to know, because the vocational witnesses' testimony is going to be at the hearing. Again, I have a pretty good idea, and I think the DOT provides a framework, but we're going to have to be a little more adroit in challenging and cross-examining vocational witnesses. So, but that's Laura, how you analyze it. Both the physical limitations. That's the starting point. You've got to be limited. There's got to be medical evidence limiting you to light work or less, and then you look at the other issues, the non-exertional, non-physical limitations, and see how they would likely erode transferability of skills, if skills transfer out of that industry at all. But there's no one-stop shop you can go to get that question answered, absent contacting a vocational witness and asking. Okay. So the big one says, my CDR is scheduled for next year, 3 years, be 51 in January. And again, I think that, 51, now you're in the grid rule territory. So, the odds of getting reversed or getting your benefits terminated are going to be a lot less. So I think that, I would not, I think as long as you continue to go to the doctor, as long as there's still medical issues, then I think, you just want to, I know you were asking about passive income. I think you just want to make sure you can provide explanations. I think what you don't want to do in a CDR is be unprepared. In a best case situation, you won't have one, it won't be for a long time. But you need to assume that you're going to get a notice of either the short form or long form where they ask you these questions, and you want to go ahead and maybe have that prepared ahead of time. You want to be prepared to have your argument and to show that you've been going to the doctor, nothing has really changed, things like that. So you don't find yourself under the gun trying to deal with a CDR issue But again, the first step is they ask you to fill out the long form or the short form. I would tell you if you get the long form, that's usually a sign that they may be looking at it more closely. So that would be of more concern than getting a short form. Okay, Sonia says, thank you for all your advice. My pleasure, Sonia. I want to type my own personal statement. Can I say I feel disabled authorities should meet the listing and why? You can use SSA Form 795 when you do it. I think that, again, the way I approach it is I would not call yourself disabled. I think that's a legal term. I would just talk about that, I don't have the capacity anymore to perform my current job. And I think it would be a real challenge, all but impossible for me to perform any other job. Because realize Social Security has this 5-step sequential evaluation process. Step 4 is, can you return to past work? So you want to address that, why you can't return to past work. And number 2 is, could you do anything else? Step 5, can you do anything else? And so rather than say I feel I'm disabled, feel that, my reliability at a job would be significantly limited because, and the reason might be I have severe back pain that causes, sciatica, it causes radiating pain into my legs. I have to take narcotic pain medication, which makes me unable to focus and concentrate. I have to lie down for, and you want to be very specific, for 30 to 45 minutes twice a day to take the pressure off my back. I think that you don't want to just look at the listing. If you could argue the grid rules, mention that. So I believe that I meet listing 1 point whatever if it's musculoskeletal. In the alternative, I would argue that I meet grid rule 202.06 because of this. And you can go through the grid rule because I could do no more than light work. I have no transferable skills, or my skills would be not transferable outside of my industry, or my non-exertional impairments would erode those transferable skills. In the alternative, again, the combined effect of my multiple conditions would leave me unable to work. That's how you approach it. But I wouldn't say I'm disabled, because that sounds like you've decided you're disabled. I would emphasize 35 years of work. I was satisfying both financially as well as a personal interaction. That the idea of not working is something that I dread. That I would much prefer to be working, but my concern is my reliability and dependability. I'm likely to be, and you can use the phrase, off task for more than 15 to 20% of the day because of pain, need to rest, medication side effects, whatever. Or I would likely have, in my current situation is at least 3 to 4 days a month, I'm not able to go to work at all because I'm having such a bad day. I can't get into work at all. So my reliability is suspect. That's what moves the meter with Social Security. So rather than say, I feel I'm disabled, say, these are my concerns about my reliability. I'm fighting this every step of the way. I hate the idea of doing this, but because my reliability is so impaired, I don't really have a choice. That's the way I would approach it. You can do that on Form 795. So that's what I would do. All right, you have another thing here, continued. Yes, okay, so yes, you want to definitely talk about the grid rules. I think that as far as the medical information, you can attach it to your application. If you do it online, you can take it to their office. I wouldn't attach it as a zip file. That's assuming they're going to open it and realize with all the viruses and everything going on, I would attach it as individual PDF documents, or you can physically take it into the Social Security office. We got more continuing here. Okay. So, all right. So I think, but if when you submit them, I would not do it as a zip file. I'd do it with individual PDFs. And if you do submit them, to the office, you might want to wait until after you apply that you have an adjudicator assigned, so you have a person to send it to. You can also fax it in, but you want to fax it to a particular adjudicator, not just to Social Security in general, because it's probably going to get lost. You've had 4 surgeries in the last 4 months, 2 surgeries in the last 4 months, need another one, 4.5 months. I would apply now. There's no reason to wait. If you're not going back, your onset date would be the last day that you worked. And the fact that you have a long work history makes a big difference. The fact that you're 57 makes a big difference. I will tell you, it is very difficult to meet a listing. So the grids might be your better argument, or functional capacity, but I would not assume you're going to win on the listing. You might, but if it's musculoskeletal, that's really, really hard. So I would focus more on the grids, which again are only for exertional impairments. The grids only apply when you have physical limitations. They do not apply to mental health. So you can't grid out if you have severe depression. You can grid out if you have really bad back pain or shoulder pain or knee pain or arm pain or something, but not for mental health. But I would use all three arguments: the listing if you've got that, the grid rules if that applies, which it appears they do, and functional capacity. And they call it arguing in the alternative. I believe I meet the listing, but in the alternative, I believe I meet the grid rule. In the alternative, I believe that the combined effect of all my conditions and medications would leave me less reliable. The main issue in a disability case is your reliability, your inability to be on task for more than, if you're going to be off task more than 15% of the day, you are disabled. If you're going to miss 1 or 2 days of work per month on a regular basis, you are disabled. If you're not able to focus and concentrate at work and need to take excessive unscheduled breaks, which again goes to being off task, you are disabled. That is legally disabled. And realize when I use the word disabled, understand disability means one thing to Social Security, something else to the VA, something else to other federal agencies, something else to insurance companies. So, when you talk about being disabled, the real emphasis in the Social Security world is on reliability. Reliability, that's what I would really focus on. Hope that helps. Okay. Rodney, one of our old clients. I appreciate you. Rodney's there all the time. I really appreciate that. Rodney, good evening to you. And I think he said happy holidays. Same to you. Appreciate it very much, Rodney. And I hope you have a very safe and happy Merry Christmas and Happy New Year. Vince, how are you doing? You made it on time. Yes, you did. How are you doing, Vince? I think, if I'm not mistaken, you're in Chicago, so I suspect it's pretty cold up there. We had, here in Atlanta, last week it was freezing. It was like 35 degrees was the high one day. And this past couple of days, it's been like in the 60s, but kind of rainy. So, not the greatest weather in the world, but, better than the 30s and 20s. I would not want to do that. I'm actually going to be in New Orleans this weekend for a wedding, which it's actually, according to my phone, we'll see if that's true, it's not supposed to rain. And I went to school in New Orleans, as y'all may know, went to Tulane. So I lived down there for 4 years undergraduate, 3 years law school. So I was there for 7 years, 4 years undergraduate, 3 years law. 7 years I was down there. And, it's known for the weather not being very good, but we're hopefully going to have a nice time. My wife and I, we both went there, so we're going to take our walk up St. Charles and visit the Tulane bookstore and get yet another Tulane hoodie. I don't know how many of them, but looking forward to doing that. It'll be just for a couple of days, but we are looking forward to that. Okay, RD. I'm 55 and battling bladder and pelvic pain. Sections of my bladder were removed. I have a small capacity bladder. That I win a lot of cases on restroom issues, RD, and I will tell you that, if you have evidence that you need to use the restroom every 45 minutes to an hour, and you're taking 5 to 7 minutes each time, that becomes an off-task problem. You're off task. You're in the restroom too much. That's number one. So you're going to have a problem with reliability. Secondly, employers and vocational experts will say they're not going to tolerate somebody continuously leaving the workstation to go to the bathroom. And once an hour is excessive. So I think that's the argument I would use there. I suspect with the pain you're dealing with, that's also going to interfere with attention and concentration and focus. So I think those things, and there may be some medications you're on that help alleviate the pain or deal with some of the bladder spasms, that might have some issues as well. But remember, this is all about reliability and having a small bladder, pelvic pain, need to use the restroom frequently. These are all things that interfere with your ability to focus, concentrate, and be reliable at work. But I win a lot of cases on that, even for people under 50. That's the one area where it doesn't really matter how old you are. If you're constantly going to the bathroom, or if you're likely to, not getting gross, but if you can't sometimes make it, you have urgency as well as frequency, and you have accidents, that's also a problem because, that's going to create a problem with reliability at work. And that's, again, the main issue here is reliability at work. Kelly is 37. I have depression, anxiety, do not initial. What should we be looking for in the exhibit disc? Well, I mean, I'll tell you, Kelly, being 37 is going to be a problem because that's very, very young. And again, mental health cases, age is probably less important, but the severity of your mental health situation needs to be pretty, pretty high. I will tell you what I look for, but this is not, I'm not speaking on behalf of Social Security. I look for what I call indicia of severity in mental health cases. These would be things like inpatient hospitalizations, psych hospitalizations, suicide attempts, multiple failed medication trials, ongoing treatment with a psychiatrist as well as a psychologist. It's got to be more than mild to moderate depression and anxiety. It's got to be something that's going to prevent you from really being reliable at work. I would get third-party statements from former coworkers, if you can get them, people that know you that can talk about what happens when you have a panic attack, what happens when you're in severe depression. It can be a family member, although again, that's going to be read with a grain of salt. But I think the more evidence you can get both medically and non-medically that yours is not mild to moderate, it is severe to debilitating at that level. But that's what you got to prove, especially at age 37. So I would look to see, what do they have when you talk about the exhibit disc? And that's the CD they'll give you, usually at the hearing stage. But that's the evidence, the level of evidence, in my opinion, you need to win in a mental health case. Can you speak on alcohol? Sandy asks, alcohol-related dementia and getting disability if someone has stopped with alcohol. Very, very good question. The answer is if, stopping alcohol will not restore the claimant's function, then the fact that it was caused by alcohol is irrelevant. The real question they're going to ask is, if you're drinking and you're saying, I can't, I'm self-medicating, I can't work because I'm terribly depressed and I'm drinking to deal with that. But the point would be, if you stop drinking, you would be able to return to work. Then the argument, or the Social Security would conclude that alcohol is what they call a material contributing factor to your disability. When you have alcohol-related dementia, that suggests this person has been drinking heavily for many, many years, to the point where it's caused organic brain damage, actually damage to the tissues of the brain, that not drinking will not restore function. And so this is now a dementia case. The fact that it's alcohol-related is irrelevant. So again, you would need evidence from a doctor that says that cessation of alcohol use will not cause any restoration of function. This is a permanent condition caused by excessive alcohol, but alcohol is not a factor anymore because the damage has been done. And I've had cases like this where people, destroy their liver by drinking, and their liver is non-functional or minimally functional, and they're fatigued and they're, sick, they're jaundiced, whatever, and they've stopped drinking. It doesn't matter because stopping drinking is not going to cause the liver to bounce back. So that's the real question is, when you have alcohol use, it's very hard to untangle alcohol use from depression, anxiety, and mental health conditions, because the question, Social Security is going to assume that if you stop drinking, your function is going to be restored. But if you've got organic damage, to the liver, to the brain, it doesn't make a difference because the function is not going to be restored. Cancer of Barbie, how are you doing? You're still waiting. Should I call your office? Certainly you can call them. Whether you're going to get anywhere, I don't know. I still think that, if you've been waiting more than 4 or 5 months, contact your U.S. Senator, as opposed to you're just calling Social Security. You can call them, but, I had a client tell me today that she called Social Security and the wait was 1 hour and 20 minutes. So, they're just really understaffed. And I think that's going to get worse before it gets better, unfortunately, because the new commissioner is he's a finance guy, and he's known for, trying to really automate more stuff and cutting staff and reducing costs. That just says to me, longer waits, less people. Okay. Susie B. Okay, you got an on-the-record request. Great. No hearing, well prepared. Excellent. Well, that's great. I mean, that just says you were really well prepared. You had a good case. Look, I had a hearing this morning. It was a good case. And before the hearing, the judge called me and said, would you change the onset date? And it was fine. It didn't really change the money very much. Call my client, like, yep, we'll change the onset date. Hearing lasted about 20 minutes, 20, 30 minutes. And really just because the judge had to go over a couple of more technical things, but it got approved. So it was not quite an on the record. It was pretty close. So that's great. That's a great feeling. And you know what? Even if you spent 5 hours preparing, that's fine. You were prepared. Keep those notes because you may need them down the road. But that's great. I'm really glad that you got a quick decision, favorable decision. That's really good. Okay, Joe asked a very good question. Asanya, do you have an assistive device like a cane or a walker? Because that makes a big difference as well. And the reason why is if you're going to make a grid rule argument, remember Sonia's 57, so if she's limited to light work and she can't lift more than 20 pounds, she's, assuming no transferable skills, she's disabled. Well, if you have to have an assistive device, and Joe talks about this, if you need a cane or a walker, by definition, you're not going to be able to do light work because your hands are tied up. You can't lift anything. And you can't really be expected to walk 6 hours with a cane or a walker. So I think that's a very good point, Joe, that if you are, if you are on using a cane or walker, then, by all means, I think that would really make you fit into light work. All right, so Barbie says, yes, 4 liters of oxygen. You meet a listing lawyer says it's a process. Again, I think that, what I would do is I would contact, and we've talked about this in past live streams, talk to your elected representative, your member of Congress, or ideally your senator, and say, look, this is what's going on. I'm on oxygen. This is causing terrible hardship. I'm listing level. Please write a letter, get them to look at this. And that's what you can do. And again, I don't blame your lawyer because, as I mentioned, you call them up, and it could be a 2-hour wait. And, lawyers aren't going to do that. I mean, we don't have time to stay on hold for 2 hours. And then you get to somebody, and half the time I will tell you, you get on hold for, after 45 minutes, you get disconnected. Very frustrating. So I think this is where a congressperson could really, really be helpful. Okay, so RD, I think is the one with the small bladder, had medically retired from a hairdresser career, 55, high school education. Will the grid rule help? Can lift more than 10 pounds? Again, the bladder issue is not really exertional, but if you have evidence that you can't lift more than 10 pounds because of a back problem or arms or wrists or something like that, then yes, the grid rules would apply. Otherwise, you argue functional capacity, the combined effect of everything together. But you could certainly argue the grids, but you have to have a physical limitation. I don't think a small bladder would count. I think it's got to be something that affects your lifting, walking physically, that sort of thing, as opposed to, a non-exertional problem of having to use a restroom too much. Okay, Big One says, thank you. You're welcome. Okay, Joe says, and I know you emailed me. I saw the email right before I got on. They've made a decision. I'll call the caseworker to let you know. They will probably not let you know. It'll be done in writing. So unfortunately, you'll have to wait. I mean, you could call, but my experience is they won't tell you anything. So that's what. But who knows? I mean, never can hurt to ask. Never hurts to ask. Rock Island. Thanks for doing this. You're welcome, Rock. I got approved for benefits for full retirement at age 67. When I turn 70, the rate will be higher, not including the COLA. So so you got approved for disability benefits. I'm not sure if I could understand what you're asking there. You got approved because with retirement Social Security, you don't have to get approved. You're basically based on age. So Rock Island, if you could elaborate more what you're asking me. Are you asking about disability, about retirement? I don't quite understand what you're asking. I apologize, but I'm not really sure what you're asking. Like It Is. How are you doing? Like It Is. You have not been on for a while. So good to see you. Okay, Jenny Joe. Good evening. Hello, Jenny. How are you doing? Mark, one of my clients. How are you doing, Mark? Erith. Erith, that's an interesting name. Erith Acevedo, am I pronouncing that correctly? Erith Acevedo for First time, well, welcome. I appreciate you stopping by. I hope you find this beneficial. You're going to a hearing after 2 denials, right? I mean, if you've applied and you're denied at initial, denied at recon, you'll go to a hearing. Realize that judge is not bound by the prior decisions at initial and recon. You're getting what is called a de novo, which means in, I think, Latin, a new, de novo, like novo meaning new, a new review. So anything that happened before does not count. And again, what you want to really focus on are the specific issues arising from your medical condition, diagnosed medical condition, that make you not reliable at a job. Either that you would miss too much time during the course of a day, you'd be off task, or that you would miss too many days of work, more than a couple of days of work per month. That is what you really want to focus on. And that's what's going to go on in a hearing. And I think the other thing I would tell you is, if you're not represented, realize that once you request a hearing, you have to make sure that Social Security is updated with a medical record. They will not do it anymore. So again, if you're not represented, make sure you get those medical records in. If you are represented, your lawyer will do that, but that's just something to be aware of. Latanya, I work in Drummond. I don't know them, so I can't really comment on it. So hopefully they've been doing this for a while, but I do not know Drummond law. I have 40 credits under medication and a home attendant, chance to win. Yeah, I mean, I think if you've got a home attendant, that right there tells me something is pretty serious. So I think that, I can't promise you're going to win, but that does tell me something is serious. Again, you got to look at the underlying medical. What are the medications? Are they, medications that cause terrible side effects? So being under medication, everybody's under medication that applies for disability just about. So, what are the medications? What are the side effects? What's the underlying condition, and how does it affect you as a practical matter? Jen is my paralegal, loyal paralegal in Lincoln, Nebraska, and she's joining us tonight. Jackie, thank you very much. Really appreciate it. Well, I'm glad we won as well. Thank you for the tip. It will go towards lunch. I think my wife brought in lunch for the in-office staff today, but that's much appreciated. I actually had lunch. My first cousin was in from Virginia, and so we had lunch today. So I bought him a sandwich at a local deli, so that I've now covered. But I appreciate that, Jackie, and I'm glad we won. That was great. It did. Okay, I think I did see your email. Like I said, today on Wednesdays, understand, just so you'll know, I have a granddaughter, 15-month-old, and so on Wednesdays, my wife and I watch it. We split her. And so one of us will go to the morning, one of us in the afternoon. Normally I get the morning, but this morning I had a hearing. So I couldn't watch it this morning, and this afternoon I had my cousin come for lunch, and then the baby was sleeping and the baby got up. And so once the baby got up from her nap, then I had to be on baby duty, which is a lot of fun, but I'm not going to be able to get any work done because inevitably my granddaughter is looking for anything she can get into that she's not supposed to get into. Any drawer that she can get into, she's pulling stuff out, she's running around, climbing on stairs. I mean, she's great, but she's, 15 months old. And so, she doesn't, she's just looking for she's got, no real attention span of anything. So she just run around being crazy, and it's fun, but I mean, wears me out. But, that's what I was doing today, but I'll get to that. One of us will get to that tomorrow. Good luck. Okay, so I think it was Erith, not Enith, Erith, E-R-I-T-H. But yes, good luck. T-Lux, hello everybody. Calvin says, hello Jen. Like it is, gives us a wave. Okay. Roy's Place is a longtime listener. You've got very good taste, Roy. I appreciate that. On YouTube, won your case. Age 59, still doing treatments and therapy. Nothing has changed. I could be revalued in 5 years. Probably not. I think that if you're 59 and they're going to look at you at 64, I mean, you're going to be close to retirement age. They're not wasting their time with people 59 years old. They're looking at people who are 35, that are 40, that could be potentially drawing against the system for the next 10, 15, 20 years. I would not, unless you go back to work and there's evidence of a lot of earnings or a major change in your condition. I think it's pretty unlikely. Okay. I'm a high school dropout. They take into account as well. Yes, because that means you have less than a high school education in the grid rules. That is a factor, less than a high school education. If you're not looking at your picture, I'm guessing you're not 50, you look young. Um, that would say to me that that's going to probably limit you to unskilled or low end semi skilled jobs. There's probably not a lot of skilled jobs. You're not going to be able to go in and be a medical phlebotomist, a medical technician. But not being a high school graduate. So I think that is going to be a factor. But realize there are jobs, and again, remember I told you the DOT is being kind of phased down a little bit. There are a lot of jobs in the DOT that were available for people that had less than a high school education and really just kind of more physical labor. There's obviously fewer of those jobs out there now because we're much more of a service economy. So I suspect that that may help you a little bit in that there are fewer unskilled labor type of jobs that a person without a high school education would qualify for. But there are still those jobs out there. So if you're younger, if you're under 40 or if you're under 50, but especially if you're under 40, you're going to have to really have significant medical evidence to really show that you really can't do anything at all. Ms. Alexander had SI fusion surgery, sacroiliac joint fusion, now diagnosed with sacroiliitis from dealing with urine incontinence. Have a hearing coming up. I think you probably have a pretty good shot at it because the urine incontinence is a major problem. I will also tell you that SI joint fusion, I don't recall ever seeing that work. The problem is, and again, I'm not a doctor, I'm just telling you what I've observed, is that the SI, the bones that the screws have to attach to are really kind of thin, and it's very hard to get them to get that fusion to hold. It's just doesn't work. I know that a number of years ago there were doctors that were doing it. You don't really hear about it too much anymore. It's just a really tough surgery, and I don't honestly I wouldn't tell anybody to undergo that surgery. And the urine incontinence. That's going to make it really hard to be reliable at work. So, yeah, I think that all those things tell me that you've got probably a pretty decent argument. Okay. And you're scheduled for an MRI, but it's after your hearing date. You could certainly, and what you might do, if the judge wants it, I would probably let the judge know ahead of time, I'm scheduled for an MRI. We can provide it to the court when it's available, and the judge might want to leave the record open, but I think you might have enough otherwise. So again, you see what your attorney says, but that's my thought. You might have enough otherwise with the urine incontinence and the SI joint issue. Steve, and CDR stands for Continuing Disability Review, and what that means is that after somebody's approved for benefits, Social Security has a set procedure where they will look at your underlying medical condition. Has there been improvement? Have you gone back to work? And they do these CDRs to try to get people off of disability. So, one area where in the past, when Congress starts to allocate money, they put it into doing more CDRs because they want people off the disability rolls. So just be aware of that, but that's what that is. And so right now, the way it works is they would send you either what they call a short form or a long form. These are forms that the short form is basically just a few questions that says, has your doctor said that you're getting better? Have you worked? Whatever. And, it's basically, if you answer no to all the questions, then it's read by machine and nothing's going to happen. The long form, they ask details. And they may ask about medical treatment you've had. They may ask about work attempts and things like that. And that's something you got to take a little more seriously. But it's just a process to get people off. What grid rule would you? I guess the question is, how old are you? And go to gridrules.net. If you're 55 or older, look at 202. And again, assuming you've got past work. 202.06, I use that one a lot. If you are between 50 and 54, you have to look at the sedentary grids. Let's take a look over here. Meaning you have to be limited to sedentary work. It would be the 201 series. a 201.06, 201.04. It just kind of depends. But I'd look at if you're over 55, look at the 202. That if you're disabled, even if you can do light work, if you're under between 50 and 55, you have to look at the sedentary grid. You've got to be limited to sedentary. A little more difficult. What percentage over age 60? A large percentage. I've not seen any specific numbers, but basically you're getting really close to retirement age. There's an assumption that at 60, there's not much you'd be able to do if you've got something diagnosed. So there's no statistics I'm aware of, but assuming you've got something decent medical wise, pretty good. I think you're in a really good position there. Anxiety, depression. So, and again, as Alexander, all these things factor into it. But I think that, you've had failed surgery, you've got sacroiliitis, you've got urinary incontinence, you've got mental health issues. All that kind of adds up to me that this is likely a case that's going to get approved. My guess, I hope. Just let SoScreen know and they will document it. I'm not sure what I understand. I understand what that means. Okay, we've talked about that. To Ms. Alexander. Excuse me, let them know. Yeah, again, I think you want, this is about the MRI in the future. Okay, yeah, I think that you want to let them know that you've got this scheduled in the future. And the question is, does the judge want to leave the record open to receive it? Or, does he want to simply informally leave the record open and receive it? Okay, let's see here. Okay, Halo Gear has got a short form for 55 in October. Nothing in the mail saying anything. Can I call Phyllis and tell me the next CDR will be? I don't think they will tell you when the next CDR will be. The short form 455 is basically asking just a few questions. And it's machine read, and generally speaking, you're not going to hear anything from them. But I don't think they're going to tell you when the next CVR is going to be. I just think that that's information they keep internal. Jenny says hello, Jen. So Jenny to Jen. Okay. Is a C exam? No, it is not a bad sign. It is done, I'd say 75, 80% of cases have a consultative evaluation. So it's not a bad sign. It's very typical. It's part of Social Security's obligation to develop the record, and that's what they're doing. Okay. Okay, they can't see decision. They don't see a recommendation for a CDR. I don't put a lot of weight into what they tell you. I think that, they're not going to tell you a lot of stuff over the phone. They basically say when it's written, it's released, that's when it comes down. I just don't buy anything they tell you, not because I think they're intentionally lying, but I just think that, they are instructed to, until it's released, there's always the chance it can be changed. And so you're generally not going to get much out of them over the phone. I don't get anything out of them on the phone. If I called up an adjudicator and said, we see decisions when reach, what is it? They won't tell me either. So you're going to have to just wait. It's a lot. Actually, a lot. There's no such word as a lot. I don't mean to be a grammar police here. A lot. But when people put a lot with all A-L-O-T, that's not really a word. So, you have a and you have a lot. So just for whatever it's worth. I'm one of these people that, I see this a lot in, I'll see people using the apostrophe for, which is possessive, like, John's car. People do it for plural. I went to several concerts, and concert apostrophe S. That's not correct. It's plural, but the apostrophe is only used when you're doing possessive. So that's my grammar tip for the day. But I do see that a lot, and it's just one of these things that just and I will tell you, because my dad was a journalist. He was a newspaper reporter, and then he owned a trade magazine. So I kind of grew up around writers. I mean, my family are all writers, so I learned kind of early on just about kind of basic grammar. Nothing. In fact, I got a really bad grade in grammar because I didn't really understand the concepts, what they were called. I just sort of knew how to do it. But that's one thing that always kind of gets my goat is when I see a apostrophe S for plural when it's only for possessive. So off my rant, but that is something that does make me a little crazy. There's a lot of other things too, but that's one of them. TBI survivor, here January says accepting as a disease have TBI. I'm not sure if I understand that question. I don't understand what you're asking me. I'm sorry, Esoteric Fitness. I don't know what you're asking me. I hear Jan SS is expecting as a disease to have TBI. So, I mean, if you're asking me, is traumatic brain injury going to continue to be a condition that could be disabling under Social Security's rules? Yes, if that's what you're asking. So there's no change to that, to my knowledge. Okay. Zippy. I have Meniere's disease, and let's see, something C on your cervical spine. Put on 15 pounds weight, got another surgery, C4 and C3, can only drive 3 days a week, be 60, have 8th grade education. Okay. The Meniere's disease, unless it's really severe, is not something that I usually see is going to win a case. It will add to other things, but you've got a lot of orthopedic issues, it would appear. Plus, with an 8th grade education, you're going to meet that grid rule. I think I would look at the grid rules. Go to gridrules.net. Let me put that down there. That's where you get the grid rules. And I think that you would likely meet one of those grid rules with that a number of things going on. No Sky, season's greetings from No Sky. Hello. All right, we got a lot of people saying hello to each other. That's good. Steve asked that, what percentage? I don't know the specific percentage. Okay, Vince, I knew it was in the Midwest someplace, not Chicago, Michigan. Okay, been mild. Okay, well that's interesting. Mid-40s, supposed to start snowing, 2 to 4 inches possible. Well, okay, you can have the snow. I guess you're getting that. You're getting lake effect snow. Actually, it would be here in Atlanta, we don't get a lot of snow, so it's a real treat when we get even an inch of snow. The whole city shuts down for like 2 weeks, but it's really kind of cool when we get it. We haven't had any the last couple of years, so we'll see if we have any this year. But it is kind of fun when we do have it, and I'm sure my granddaughter will be quite intrigued by it. In fact, when my wife was pregnant with my son, it's going back 30 years. I mean, he was born in 1993. So this is in the March of 93 in Atlanta. We had a blizzard, and my wife was 7 months pregnant. So she decided, well, we're going to go out on the sled. So she's got my daughter, who's almost 2 years old, on the sled. And of course, she wipes out on a hill. And I'm thinking to myself, great, okay, I'm going to have to deliver a baby in the snow, a 7 month, a woman who's 7 months pregnant, I mean, I get queasy when I cut my finger. I mean, so fortunately nothing happened, but I'm like, we could not have gotten to the hospital. We had like ice and snow. So I'm like, would you please do not do that again? So that's my snow memory. But we had a blizzard in 93, and we really haven't anything quite like that since, but it is kind of fun. So 2 to 4 inches, hopefully enjoy, but I suspect it's going to get real old real quick, Vince, in Michigan. Okay. Flashbacks, that's going to interfere with attention, concentration, and focus. Okay. What's the chance of a CDR? Again, if you're 60, close to 60, I think the odds are pretty slim, in my opinion. Will it make it harder to get a job for people if they were on disability, if they do have to work into financial difficulties despite being disabled? Yeah, I suspect it would be. I mean, I think that, if you are disabled, you're going to be a more difficult, hire, because the employers are going to look at you and say, this person was already out for and deemed disabled by the government. How reliable is this person going to be? And to my knowledge, and I'm not an employment lawyer, but I don't know that disability, I know there's the Americans with Disabilities Act, but, if the state is an at-will state, I don't think they're going to say to you, we're not hiring you because you are disabled. So I think it's a practical matter. Maybe legally there's protection under the ADA, but as a practical matter, I think it will be more difficult. Absolutely. That's just the reality of it, I think. Okay, TBI survivor, PTSD, anxiety, BPD. I'm not sure if I know what that is. 49 years of age. I'm not sure if that's prostate. I don't know what BPD is. Let's take a look. See if I can look up BPD, medical abbreviation. It says, stand for two different things. Borderline personality, that's what I'm guessing it is. Borderline personality disorder, or it can be bronchopulmonary dysplasia. It's a lung condition that affects infants, so that would not be it. So I'm guessing borderline personality disorder, TBI, PTSD. Again, the fact that you're under 50, you're right at close to 50, so that helps a little bit. Again, I get back to the indicia of severity. Have you been institutionalized? Have there been suicide attempts? Have there been violent outbursts? Have you had multiple failed medication trials? Are you getting ongoing treatment from a psychiatrist, psychologist who will support you? These are the questions to ask. So it's really not about the diagnosis. It's about the severity of it and the symptoms you experience. Do you have, with borderline personality, are you triggered by certain things, by people saying certain things? The PTSD, what are the triggers for that? Maybe it's having a person, a male with a beard in the room or as a supervisor. Or maybe it's a loud noise. I mean, any number of things, but you need to know what those triggers are, which I'm sure you do, and you need to have some support from your doctors discussing the severity of the condition and the practical effect of it. All right, Aerith has fibromyalgia and bulging disc, 59. I will tell you, Aerith, fibromyalgia is a tough road in the Social Security world because it is a diagnosis of last resort. There is no objective test for it. You can't take an MRI to see fibromyalgia. I think the disc issues are going to be stronger for you. Not to say that fibromyalgia is not relevant, but unless you meet the American College of Rheumatology definition of fibromyalgia, it's going to be a hard road. So I think I would probably focus more on the things that are objective, like the bulging discs. That may be a stronger argument, but again, if you have an attorney, I would defer to that person. Okay, I think you've got a hearing. Again, focus on the functional limitations, functional issues. All right, Esoteric has got some of these mental health conditions, now needs a cervical fusion. Again, what that says to me is that there's physical and there's mental, and you add those together and really think about the functional limitations. What are they? And how severe they are. You don't win because you need a cervical fusion. You win because your arms are numb, you can't lift anything, or anything over 5 pounds. All right, Michelle, right now I'm an FMLA and doing short-term disability through work. Paid for, I have been diagnosed with breast cancer. I'm sorry. I have a hard time getting back to work. It seems like get rid of one issue and then something else pops up. I think that, again, if you're on family medical leave and you're not sure you're going to be able to go back or you'll have a job, if you haven't applied, I'd apply. I think there's no reason not to. With breast cancer, and I had a couple of breast cancer cases recently, there's obviously certain procedures. They could do lumpectomy, they could do a total mastectomy. It just depends on what's done. Are you going to need residual radiation? I have a case coming up, I believe it's tomorrow, where my client had breast cancer and went and had developed cellulitis because the radiation caused damage. So again, the complications are going to be those things. So I think that your case sounds like it's going to be a combination of factors that, when you add them all together, indicate you would not be very reliable at work, as is being shown in real life. You are missing so much time that you're probably going to lose your job because you're not reliable enough. And that's really the argument you're going to be making. You've been making in disability. Okay. But I'm very sorry to hear about the diagnosis, Michelle. That's tough. Oh, I forgot one up here. Muley says, you've got a picture of an elk there, not a mule. So, okay. I talked with SSDI about my 100% VA. They said they flagged it. First payment with a percentage. Could they miss that and not move me up? Could they have missed it? Yep, they could have missed it. They miss stuff a lot of times. I would reiterate to them in writing that you're 100% permanent total by the VA. Just keep letting them know. I mean, if they're not expediting, and they should be, but I would definitely let them know again. Thunda 10453. Good evening. I'm at step 4, representative conducting final review. Step 4 means nothing. It's just arbitrary number. It just means they're conducting final review. It means that they've gathered medical evidence. They've had their in-house doctor look at it, and the adjudicator is making a final decision. It has not been made, but that doesn't tell you what it's going to be. So it sounds to me like you should probably get a decision in writing in probably 1 to 3 months, if I had to guess. That's what that means. Okay. Coup Thunder. Applied in fall of 21, denied last week at the ALJ, currently 54 and 8 months. 5/6/2004 strength. SVP rule. Oh, that's your 202.1 for a different rule been used. Okay, you're 54. So 202 is the sedentary, or the light grid for people over 55. Now, there isn't a way where a judge could look at a person 54 and 11 months and say, we're going to basically use the grid framework and apply the grids as if they were 55. I don't think it goes back as far as 54 and 8 months. So I don't know that 202 would be the appropriate. I mean, that would be a reason to let's see what 202.04 says. 202.04. Well, that would disable you. You're a 55 plus high school graduate or no direct entry into skilled work. But again, if you're 54, 202, you need to be 55 plus. So I don't think that that's the right grid rule to have used. You could have used 201.04. That's a high school graduate, 50. I'm sorry, that's not the right one. Pardon me. 201.12. 50 to 54, which you are, high school grad or more, no direct entry into skilled work, unskilled or no work background, that would make you disabled. Or 201.14, same thing except no transferable skills. So I don't think the 202 grids would be appropriate. Look at the 201s. But the ALJ denied you. You need to look at this for appeal to see if there's any grounds for appeal. Okay. I'm not, Latanya, I don't know Drummond Law. They may be fine attorneys. Hopefully they are. But I don't want to get into other law firms because it's really not, I don't want to, positive or negative. Again, I'm going to assume they're fine, but I would not get into that just because this is really not the forum to discuss, other law firms. You can talk about me, hopefully nicely all you want, but I would kind of stay away, or my guests, but I wouldn't talk about other people that are not here. We just don't want to get in any sort of trouble there. All right, Elena Pavlenko. I'm 38, have an ongoing SSDI case, the recon stage. I'm interested in writing my own dire newsletter. Okay, well, dire need, I think you mean dire need, would be that you are about to lose your house or your car and you need a fast decision. You could do that. I don't know that it really moves the meter that much anymore because they're so backlogged. I think a better option would be to contact your U.S. Senator or representative and see if they will start a congressional inquiry. That's going to move it along faster. I'll also tell you, Elena, at 38, you got to have a lot of stuff going on. That's a very young person to get on disability. All right, Steve, I think I've answered this. What percentage over 69? Well, 69, you're not going to, you're already in retirement. But you've asked what percentage over age 60. there is yeah, 60 here. There's no statistics that I'm aware of that answer that, but I think it's pretty high based on my experience. Okay, Michelle is at the recon stage. Reconsideration, not considering reconsideration stage. Realize that recon, only about 15-16% of claims are approved. So don't be upset if you get denied at recon. Very small percentage of cases are approved at recon. Sharon is telling us it took her 2 years. That is not unusual, unfortunately. RD, are you female over 35? Oops. Supposed to call today and I got sidetracked, and she's going to be unhappy with me. So Sharon, if you know who you are, if you're listening, I apologize. I will get to you tomorrow, and I will leave myself a note. Like I said, my cousin came and my granddaughter got up, and my daughter didn't pick her up until late, so it just was a bad day. Okay. Okay. TBI survivor. Again, it just depends on the specifics. Why is DDS in the Human Services Department? Because DDS is a state agency, and that may be in your state what it's called. So even though Social Security is federal, there is a state agency makes the decisions or does the evaluation on behalf of the federal government. That's why this you may call it Human Services. Every state's got a different one, but that's what that is. Okay, so we're getting some advice for, I think this is RD, and I'll just leave it as it stands. I'm not going to make any comment, but I think that the sentiment is correct. You want an expert. I would agree with that. Okay. Menopausal specialist. Okay. Hormone replacement by cognitive decline. Okay. All right. So RD says thank you and happy holidays. So a lot of people are concerned about you, RD, and I think some good advice. Good advice. I think they should give every person applies for depression SSI check. Well, the problem, Latanya, is first of all, SSI is not the same thing as SSDI, but I think because people apply. The counter argument is that, anybody who wants money is going to say, I'm depressed. And, they've got to have some standards. I mean, I don't think that you can just walk in and say, I'm disabled, pay me. The question is, are these standards too difficult? But just walking in and saying, pay me, no. I don't think that's ever going to happen. I don't think it should, quite frankly. I think that, look, most of us are or have been taxpayers. And so you want to think that the government is going to be a good steward of your tax dollars. Should they be on the unreasonable end of things? No. But, I think there's got to be some standard for disability. Someone said as of 2024 as accepting TBI being a disease. No, that is not true. That is not true at all. TBI, traumatic brain injury, as a neurological condition is still very much a part of the Social Security world. So that is incorrect what you heard. Theodore. Okay. SSA laws here in California are so dumb. Dumb, okay. I got denied due to lack of responsibility with the law firm representing me. They're terrible. I got denied by a federal judge, need to appeal it to the Ninth Circuit. Well, first of all, Social Security laws are federal. They're not in California. So, it's not a California issue. It's a federal law issue. You're denied at the appeals council. You're denied at federal court. Appealing to the Ninth Circuit, you're going to have an uphill battle. The Ninth Circuit is a level below the Supreme Court. It's got to be something pretty significant. So, again, I obviously don't know anything about your case. It's going to be hard to find a lawyer to do that. Let's just put it that way. Okay. Rock Island. Aloha. Okay. 61 I got approved. Might want to get with 67. will not increase. Okay. So no, I believe that, well, let me ask, I'll put it this way. Actually, yes. If you are approved for disability and you got the amount that's equal to full retirement, at full retirement, they convert you over to Social Security retirement. So it's a different trust fund paying it. But that amount does not increase. If you didn't wait to take your full, in other words, if you waited till 70 to take full retirement, you get a higher amount than you get at 67, right? But if you got on disability and they paid you basically the full retirement amount, that will not go up as you get older. So it will not go up, is the answer to your question. But you will get COLA, but you will not get the amount you would have gotten if you'd waited until 70, not been involved in disability, and just taken late retirement, we'll call it that. So no, you will not get more money. Okay. Natalie, how do we get back pay direct deposit records? SSA tried to direct deposit first and rejected because of the bad bank account. Never tried to send me the same amount to the right account. This is a issue that hopefully they have not kind of, your money hasn't gone into, nowheresville, because that does happen sometimes. I think this is a situation, honestly, one of the few times I would tell you to make an appointment and go in person to your local Social Security office to get this straightened out, because it's going to be hard to do it on the phone. You want to go in person, give them the bank account information, get that straightened out, and make sure that your bank is going to honor the deposit, because you don't need that, happening. So yeah, I think I would go in person on that. All right, Jen, good evening. Cajun Sunshine, and I don't know, I don't remember the name, so I will accept that you were one of my clients, but I don't have a client named Cajun Sunshine, so obviously there is another name there, who you are. And the picture I don't recognize either, so maybe give me a first name and we'll have a better idea. Okay. Yes, actually, Randy, what's going on here is we started the claim, they started processing it, I'm going to finish it. So it's in process right now, so it's going. And we'll get it finished. But that's what's happening, because when you start an application online, after, they will sometimes start processing it before we finish the whole point of it. So I have to make the changes you sent me, and I'll do that, and that's on my docket for tomorrow. But yeah, we're in process right now. Nini, I have a case for the appeals council. My attorney was given more time. No, it just means that your attorney's asked for more time and the appeals council has given your attorney more time, but they have not made a decision yet. So it just means that, this is not uncommon. The attorney said, I need more time to write my brief. They gave it to him, but it doesn't affect the substantive issues at all. Nevada, I wanted to know, if you get approved for disability Medicaid, will you get approved for disability? Also, is it a home aid that takes care of you? Well, first of all, Medicaid goes with SSI, not SSDI. So if you're talking about Medicaid, that means you're going for SSI. If you have a home health care aid, that is usually a sign of something pretty significant. Again, I don't know what your underlying medical issue is, but if it's something that requires a home health care aid, it sounds like it's pretty significant to me. Okay. Just me. Hey, and y'all that's a Southern phrase. Hey, y'all. So that's what we talk about in the South. How y'all doing? So that is good English as far as I'm concerned. Okay, let's see here. Let me go back to this. All right, Johnny number 5. Well, was there a Johnny number 4 or number 3? But you're number 5. Okay, well, you won my advice. Well, you know what? I suspect that your underlying medical condition was more important than my advice, but I'm hoping that, look, part of the reason I do this is to educate people about what this process is about. So if anything I've given you has been of assistance, I'm very gratified. Leave me a nice review. Let me put that on there. That would be that's what I would ask you. Just leave me a nice review that my advice was helpful to you, and I would be really, really grateful for that. Miss Michael I'm 48 with a 7 millimeter bulge disc. The sciatic pain comes and goes. Last 2 weeks, 2 months, the pain subsides. Super painful disability case. You're 48, so you're not 50. That goes against you. The pain, it sounds like, again, there's an MRI show, it's a bulging disc. Is it impinging on the nerve? What causes it to get really, really bad? And I would say would say to me that's a little bit of an uphill battle. It happens 2 to 4 times a year, really painful when it happens, but it's not consistent, it's not constant. So the question would be, if you minimize your activities, would you be able to avoid missing work? Because it's hard for them to say you're disabled when you might miss work 2 times a year. So I think the frequency of the pain flares is probably going to be less than what they would want to see to approve you. So I would say it would be an uphill battle. Not impossible, but it would be an uphill battle. Have I had success getting people on that have same TBIs? It really depends on the severity of the TBI and the symptoms that arise from it. It kind of depends. Was there organic brain damage? Is there something showing, something there that would explain the cognitive loss? Have you had? Here's the real issue, or the real thing I would tell you with a TBI. Have you had a neuropsych evaluation? And if so, does it say the damage you've incurred because of the TBI is such that you would not be reliable? This is really one where a neuropsych evaluation is almost going to be essential. And so if I've got a supportive neuropsych evaluation, I'm going to probably win. If I don't have one, it's going to be more of an uphill battle. Because again, a TBI in many cases is invisible. You take a brain scan, brain MRI, and it doesn't necessarily show anything. And so TBI can both be physical in terms of brain damage, or it can be, emotional. It can cause issues with your psychological functioning. So, but I think a neuropsych evaluation would be really necessary. Great, Teresa. Advice in watching videos. Good. A lot of people say they watch all these videos, like 400 videos you watched. You're a glutton for punishment, but great. That's why I do them. And again, obviously not everybody watches the videos, hires me, but I've said this over and over. Good karma. You put it out in the world, it comes back. So I'm pleased that you got benefit from it. And thank you for commenting. I really appreciate that. Aerith, thank you, and happy holidays to you as well. All right, Trish, how are you doing? It's been a while, but you were not here. Don, but I don't think did I skip you, Don? I'm sorry. I don't see. I'm looking up here. I don't see anything from you. So, if you wouldn't mind, I'll make sure I get to it. But just go ahead and rewrite your question, because I don't see you up there. I could have skipped you, but I don't see you there. So Alexander's 41, and again, that makes it a little bit more difficult, because 41 not the same as 51 or 61. You're younger. His bottom line is. Do I take cases in Florida? I think I did answer your question, Yelena. I do take cases all over because it's all done by phone or video, which, by the way, let me just go back to Yelena's. Here it is here. 38 years old, reconsideration. I did answer that. And the answer was, it's a dire need letter, but I think a better option would be to contact your congressperson. 38 years old is, you've got to have something really, really severe. You're young, very young for disability. So, in my view, unless you've got something that is just completely limiting your functioning, either physically or mentally, it's going to be really hard to win. Not impossible, but very, very difficult. Okay. I took a 4-mile walk today with the dogs, so that's why I'm yawning here. Plus I'm old, but I do take clients from Florida. Okay, Eric Bishop. I just received a partially favorable with onset of January for appeal it. I believe that, yeah, and I get this is what happened to Eric. I've had this happen to several of my clients. They approve you, but they change the onset date to get rid of your past due benefits. The answer to that would be A, how much did they, I would call it cheat you out, or how much did they reduce it by? If your original onset date was September of 2023, probably wouldn't appeal it. But if it was September of 2021, and I had a case yesterday, I was talking to my client, $45,000. That's how much he would be losing by using the immediate onset date. I'm saying I think you should really think about appealing it. So I think the amount of money you'd be out would be a factor. I think the medical, is the medical really supportive of the earlier onset date? Age categories, if they approved you as of age 55, that might make you think twice about appealing it, because now you've got to, show that you were deserving of approval at age 53 or age 48 or something. So I think these are all the factors you got to consider. I just can't answer that because it just depends. Eve has ADHD, severe depressive, general anxiety, autism, didn't work to work on 22 months, work full time, life's hard. And I understand that. And I think that, all these things, if they're being treated and you have supportive doctors, even if you're younger, I think that that would be a case you could certainly pursue, because again, I think you could make an argument that you would not be a very reliable worker with the symptoms that these conditions likely cause. But again, that's got to be documented. You can't just walk into court and say, I've got these terrible, symptoms here. I'm terribly anxious. I would miss 3 days of work a month. You got to have a doctor say it. Psychologist or psychiatrist, not a social worker. It's got to be a medical doctor or a PhD type person. Okay, Martini shot is 60. Zillion medical tests. They sent me more questions by work. Is that the norm? It is a norm. It is normal for them to send you questions about your past work. There's forms for that. Social Security is known for a lot of forms. And I was going to get to this before. They've come up with this new thing, and this is just an example, and I don't mean to really harp on Social Security because I realize that a lot of people there are doing the best they can. And I'll just make this real quick. But as of COVID, we went from in-person hearings to virtual hearings. And so at first there was a form, it was this mimeograph form, it looked terrible, where you basically would check a box saying, I'm okay with a telephone or video hearing. And it looked ridiculous, but it wasn't properly worded. So the NOSCR, National Organization of Social Security Claimants Representatives, comes out with another form that we've been using for the past several years that basically says, I agree to a phone hearing, I agree to a video hearing, I want a live hearing. Working great. Now what they've done is they're sending out to my clients not one form, but like 4 different forms. One of them says, I don't want I don't want a video hearing. I don't want a telephone. It's in the negative. Or I don't want I do want an in-person. I mean, bottom line is it's really confusing to everybody, because instead of one form with all this stuff on, they got 5 forms. So I don't know what's going to be. I'm not sure if they're going to still honor my original NOSCR form, which I submit twice to them at the initial part when I send my appointment representative form in, and when I request a hearing, or they're going to require one of these new forms. I don't know. But it's just an example of, there was a simple fix to this problem, one form where you made your choice. Now it's 5 forms and they're sending them separately in the mail. It just makes no sense at all. This is just beyond stupid, and it's going to cause nothing but confusion, and people aren't going to know what to do. They're going to fill it in one form, send it out, and the next day get a different form, and they're going to send that in. It's going to have Form A is going to say, I want a telephone hearing. Form B says, I want a live hearing. That's what's going to happen. It's just the stupidest thing I've ever seen. But this is an example of, Social Security having people that don't, have not really thought through the way this is all supposed to work. So, rant over. Yeah, and I think the meds, Eve, are going to be, a factor as well. Okay, no New York. 25. Okay, so again, 25 is uphill battle because you're very, very young. But with mental health, it's not as big of a deal. Now, the question is, do you have enough credits for disability? Are you in SSI land? Go to ssa.gov/myaccount to see if you have enough credits. You might, again, I know it's easy for me to say, work a few more years to get the credits to qualify for SSDI. That's a much more robust program. Plus, the older you are, the easier it's going to be to win. But I think big picture, you're going to need real strong support from your doctor at 25, 26. Okay, Latanya, I know you've asked about this. I'm not going to talk about Drummond Law. Okay. Don't really know what that means at all. Okay, struggle is real. Yes, dire. I understand. You said dire news, dire need. Yeah. As I said, you could write your own dire need letter. It's going to basically be that I'm in terrible financial hardship. I need a decision sooner rather than later, because I've been waiting, I'm about to lose it. And typically for dire need, you're going to say, I'm about to be homeless. I'm about to have no transportation. But the problem is they're overused. I think a letter to your congressperson makes a lot more sense. But if you want to write a dire need, that's what you would say. It just doesn't carry the weight it once did. But you got to include in there